Adam. I'm Chief Strategy Officer at Innovate Finance, the UK trade body for fintech, for digital assets, and also for RegTech. I lead our Digital Pound Foundation, which champions stablecoin, and I'm on the Bank of England's central bank digital currency. But I feel quite parochial and kind of little Englander compared to the rest of our panel, because we're going to take a tour of the world in the next 50 minutes. So really looking at developments around the globe in terms of crypto asset, digital asset, regulation, and legal policy. We've got a fantastic panel to guide us on this journey. Delighted to have Emma Channing, partner from Spencer Fane, based in Denver in the States.
Based in Denver, I'm an attorney in England and Wales, California, Colorado, and New York. I'm a FINRA registered rep and a blockchain software developer.
Thank you. So dual qualified. We have Sara Hall, partner at Walkers, and you specialize in global financial services, but particularly offshore. So you're going to guide us through all of the islands, I suppose. And then Yiannos Ashiotis, who you're on the board of Revolut Digital Assets. Revolut, who moved to their new HQ in Canary Wharf just yesterday and had the chance of visiting. And you also particularly focus on both the EU and UAE governance risk compliance. So you're co-founder and managing partner of Pinks Hill in the UAE and a managing director of GRC in Cyprus.
That's correct.
So again, we're going to, I guess, look at both sides of the Mediterranean and around Europe. So kind of without further ado, what we were going to start off with is a tour of the world with the panel. And then after that, I want to look at kind of just comparing and contrasting, particularly around the kind of the legal regulatory approaches. Then what it means for markets and clients. You know, what type of businesses are picking where to fit with their business strategies. And then looking ahead of how do we see this developing? What do we see as the regulators and the regulations models going forward? And kind of finally wrapping up with, do we see a convergence or are we going to see a kind of disparate multilateral world? And we will have time for questions at the end. So as we go, kind of keep on top of your mind or jot down what your questions are, and then we'll come out to the audience. So kicking off, can I start with Emma in terms of the US? Obviously, kind of hitting all the headlines in terms of crypto asset regulation. And I should say for everyone, we've got 5 minutes per jurisdiction or group of jurisdictions. So just giving us a sense of what's happening in your market or markets in terms of the regulatory approach. What's exciting you? How advanced things are. So Emma, if you want to say a little about the US.
Sure. From a crypto perspective, we tend to look to sort of 3 or 4 main buckets in terms of US legislation: securities law, tax law, banking law. We have both federal and then very innovative state regimes, particularly Wyoming. I'm going to just put it out there. There are issues with the Trump administration, and I'm going to put them over here and firmly focus on the aspect of the Trump administration to digital assets. We have seen, from a securities law perspective, a number of things happen. Paul Atkins, who is very pro-crypto, as well as a white shoe law firm partner, was appointed chairman of the SEC. We've seen a number of clear-outs of the overly aggressive enforcement team, as well as the accounting team at the SEC. We've seen a number of progressive developments where a number of overly aggressive, what we call drive-by securities law cases, were dismissed. The one sort of exception to that bucket was SEC versus Ripple, which was settled with a $50 million fine. It took a while to crunch that through the courts, but that has now gone through. We then, and sorry if I'm beginning to sound like a hamster, there's just a lot to cover. And then progressively, we've seen additional developments coming out of the SEC. Most recently, One of the key things that was held up the ETH ETFs last year was exchange necessary rule changes for those to be listed for exchange-traded funds that we've just seen last week. The SEC adopt standard rules for that. There's a number of other developments that are just smoothing the way for, ramping down enforcement, ramping up development of products within a securities law framework. From sort of a banking law perspective, we've seen a number of things. Firstly, what was called Operation Choke 2.0, which was the debanking of a number of crypto asset holders and crypto companies, has been ramped down. The Fed and the OCC have withdrawn a number of very aggressive policies. What's more, it was a nasty intersection between banking law and securities law, something called Staff Accounting Bulletin 121, which was a SEC policy that was stopping US banks custodying crypto, has been revoked and was from day one of the administration. We have also seen a real uptick in interest of crypto and digital asset banks and custodians obtaining OCC charters. So one has been granted, and there will be hopefully additional ones. And then finally, from a tax perspective, again, it's political appointment. Crypto, confusingly in the US, is taxed as property, and there's no what's called 1032 exchange. So you do get taxed whenever you sell a crypto asset, even if you are selling it into another asset. So that is really kind of the last piece to smooth things. And then finally, from a legislative point of view, the Genius Act was passed about a month ago. It went in reverse order. It went from the Senate to the House and then was signed into law by the President. That requires both the SEC and the CFTC to bring legislation into force next year. So it's not currently in force. It just applies to stablecoins. The Clarity Act, which is focused on market structure, has passed the House. It's now in the Senate. There was an RFI that was due, which I worked on with the Wall Street Blockchain Alliance in terms of a response. That was a 74-question RFI that had to be responded to in 2 weeks, but that gives the Senate a vast amount of information from industry experts, and we're just seeing a massive flow onshore of companies that had left. We're seeing a lot of interest in coming onshore. We're seeing a lot of M&A activity. So it's a very positive time.
Yeah. I realise how unfair the kind of 3 to 5 minutes for jurisdictions, particularly, was like, well, US is just one country, but a lot of states, and kind of a 360-degree turn, I suppose, from really a hostile environment in many respects to a very supportive one.
Yes. So the Biden administration, unfortunately, even though the House and the Senate had voted on the basis of guidance for the General Administrative Office to overturn SAB 121 because it was policy by the back door, the Biden administration, for no particular clear reason, vetoed the overturn of it in May of last year. And I think that led to a great deal of interest by crypto in the election. Just in 2023, the estimate of how much the crypto industry had to spend on litigation defense against the SEC was around $500 million. There was a 3,000% uptick in enforcement between 2023 and 2024. And that has just ramped down and gone. Commissioner Hester Pierce and a number of other SEC members have made it very clear that there is still a need to enforce laws. Appropriate SEC litigation will continue to be brought, but the incredibly aggressive, frankly baseless harassment of the industry, that's gone, and the people who are responsible are also gone.
Okay. That's at federal level. Has the same change? Have you seen the same change in approach at state level, or is that more of a mixed picture, or is it less relevant?
This was very much a federal campaign driven by the Biden administration. It was not easy under the previous Trump administration by any means, but this very aggressive activity of the last 4 years that was driving people offshore, and we were just increasingly saying, to the extent that you can not touch, and it's one of the reasons why I like being dual qualified, because I can say to clients, if you have no nexus with the US at all, we do this under English law, you don't touch it. There's no reason to double the length of your document under New York law. But this was very much a Biden and Elizabeth Warren driven policy objective that never had any clear basis, and it was harming the American people, it was harming American innovation, it was driving, and I think perhaps the anxiety that you're hearing in my voice, I certainly had a sense, and I know a number of my colleagues did, that we were seeing custody businesses, other businesses, increasingly going offshore, and these businesses and these people were not going to come back, at least until things changed. And I think the speed at which people have turned around is very gratifying to see, and just confirms that this was a really necessary root and branch shift in policy.
Super. Well, that kind of tees us up to Sara, I think, because you've sort of mentioned people going offshore. You cover all of the offshore jurisdictions.
A number.
A number. Where are they? And I guess including where were they before the developments in the US, and where does that leave them now?
Yeah. So I specialise in Cayman Islands, Bermuda, British Virgin Islands law, and our firm also practices the laws of Jersey and Guernsey. As many of you will know, these jurisdictions are not independent of the UK, but they do have their own parliaments, and they pass laws in a very nimble way. What we've certainly seen over the last 5 years is a move of many businesses that would love to have been onshore in the US, have a dual strategy, essentially. So many of our clients have established in Bermuda, Cayman, or the BVI, and in parallel continue the advocacy in the US. But with the change of administration, they've now successfully been able to add to the offshore strategy. I think it's fair to say that we, including myself, refer to offshore in the same way that we'll sometimes say Asia or Europe. The jurisdictions each have their own specialist products, and they all have their own different policy objectives. So Bermuda, almost 10 years back, as many of you will know, the insurance industry essentially is one of the main pillars of Bermuda's economy. Bermuda decided to diversify, and there's been a policy objective for about 10 years of attracting regulated digital assets business to the jurisdiction. So what we've seen over that last 10 years is really a development of that regulated business, very granular policies and procedures being required of businesses. Very much feels like a highly regulated jurisdiction, which it is, but with the focus on ensuring that the requirements are bespoke for a digital assets business. The regulator is very innovative, so it will consult with industry, listen to industry. For example, this year it put out a consultation on whether or not to regulate DeFi, and if so, what that might look like. It put a few ideas out there in the consultation, but it's a very collaborative regulator and is really looking to work with industry to make sure that Bermuda is sort of the bedrock is safety and soundness, like insurance, but at the same time being nimble enough to remain competitive. Looking at Cayman is, many of you will know, it's an investment funds jurisdiction, wholesale markets, investment funds jurisdiction. Cayman is open for digital assets business. We act for Ripple. It's recently got, they call it VASP in Cayman, so it's recently got a VASP registration. The interesting thing about Cayman is very much focused currently on the tokenized funds, development of what that policy should look like. We do many investment funds. We've got a big Cayman investment funds team, and they have done many tokenized funds. So there is market certainty there that it's possible. You just need to have your fund regulated by the regulator. You don't need an additional digital assets license. So we're seeing an uptick in that business, but we're also seeing the regulator looking at, is any more regulation required? And then looking at BVI. BVI is never at the vanguard of innovative financial services regulation. It's very much a follower. It does not want to be at a competitive disadvantage by putting something very innovative that's going to drive business elsewhere. But all of the three jurisdictions have as their bedrock essentially an AML registration regime, which does require, I'll say, quite heavy-duty AML compliance. The word registration is a bit of it's a bit deceptive, because some people think, well, I'll fill out a form or an Excel spreadsheet and I'm good to go. Both Cayman and Bermuda have put out quite extensive guidance about what good looks like. Particularly Bermuda in the last 4 weeks put out a very long paper about if you're applying for one of our licenses, here's quite a granular guide of where the bar is and how to meet that standard and then continue to meet it once successfully registered. A final note on Jersey and Guernsey. So Jersey has looked at what the other offshore jurisdictions are doing. It has a tokenization regime in place, which it's updated very recently, which doesn't require a token to be regulated, but it requires the regulator to look at it and to ensure it meets certain standards. So Jersey has had a huge uptick in tokenized business. That's been very successful. Guernsey had been, let's say, more nervous about rolling out a digital assets regime, but once it saw how much business Jersey was attracting to the jurisdiction, it could see in the other jurisdictions that digital assets business could be successfully regulated without undue risk to the jurisdiction. Guernsey has very recently made a sort of policy move now to begin to welcome digital assets business to the jurisdiction.
And how much, Jersey is a good example where they've had a crypto asset regime for quite some time, but equally as a market as a whole, they then very much work with businesses who are then trading on the London market. So it's kind of the relationship between the offshore and then the main onshore capital markets. Does that mean regulation in that larger kind of liquidity pool has a knock-on effect? What's the kind of relationship between the, if you like, the sort of the primary capital market and the offshore centre?
Yeah, very good question. We always work very closely with other counsel in different jurisdictions. I always say to my clients, our offshore jurisdictions can be seen almost like manufacturing centres. The domestic market of Bermuda, the domestic market of Cayman is not really going to be where your revenues are going to be generated. So we always say to our clients, think about the distribution strategy. It's like any other product. Think about how this is going to be lawfully distributed, because obviously if you can't get your product away lawfully, then you can't get your business off the ground. So Jersey, as you say, has a very close relationship with the City of London. But equally, we always talk to clients about if the EU is one of the, let's say, target markets, even if they're not actively marketing, we will always say, speak to EU Council if the US is a market where they'd like to attract business again. We always say you have to take advice to make sure the distribution strategy is going to work before you actually come to us to set up the, shall I say, the factory, for want of a better word.
Excellent. There's a logic for you sat between Emma and Yiannos.
Yeah, if I could just jump in, just to clarify a couple of things. When I said offshore, I meant just literally leaving the US into the rest of the world, not more into the jurisdictions. Secondly, those kind of typical structures that we see in funds, and particularly tokenized funds, which we'll see more and more of, a structure we've used quite a lot is Singapore Topco, Cayman, then US. That kind of structure I think we will continue to see regardless of what's going on in the US. And finally, I think most digital asset companies are always just very fluid and very sanguine about where they're based. Yeah. From a Topco or otherwise corporate structure, and I don't see that changing either.
No, you're absolutely right. I mean, one of the USPs, I think, of each jurisdiction is it's very close to industry, it's very close to the market. And for example, Cayman has regulated as well as unregulated products. And it does tailor the laws to make sure that there is market certainty at the same time as innovation. Because as you say, clients like a sort of well-trodden, they want to be in the herd, essentially, normally. They don't want to be the lone wildebeest trying something new out that the regulator might knock on their door.
And I think maybe
more uncomfortable, I think, for some.
Yeah, and I guess relevant as all of this becomes more and more mainstream, that must accelerate. Moving on, Yiannos, you're kind of like both look at maybe one of the more established markets and established regulatory regimes. So MiCA feels like it's been around for a while now in Europe. And then kind of one of the most exciting kind of developing areas in the Middle East, where we've got global financial centers developing and kind of evolving their approaches. So kind of, I guess, what are you seeing in both of those, and both, similarities, but also the differences, even the differences between different states in the Middle East?
Well, let's start with Europe. I mean, so we started from the west, going east. I think it makes more sense to go to Europe first. Now, MiCA was indeed probably the first solid regulatory framework that was dealing with crypto. And I mean, for the lawyers or the people that dealt with MiFID, I mean, there's a lot of similarities. I mean, if you look at MiCA and you remove the references to digital from all of the text, you're going to see that some stages, some areas, it's as if they just copied pasted MiFID into this new digital regulation framework, right? But at least we had something. We had something which was solid. It made sense. It was a little bit archaic because it kind of referenced MiFID. So basically, it was based on financial instruments and financial services in the traditional sense. But at least you had something that was solid, and it was way ahead from everything else, with the exception of, to be honest, Switzerland, that has its own framework, but has been left out because, I mean, we see nowadays that regulators are not willing to give the Swiss the equivalent jurisdiction, so they cannot interplay with any other jurisdictions on an equal basis. So MiCA came about, MiCA was implemented beginning of the year. Everything was great, but unfortunately, it seems that we started seeing a lot of cracks. And this is very worrying for me, and I think it's worrying for a lot of people, where the whole concept of MiFID back in 2007 was to create a common playground in the European Union that would facilitate the European idea of free transfer of people, ideas, services, and capital across countries. With MiFID II, you started seeing some additional powers being bestowed on national regulators.
Yeah.
And then with MiCA, even though this wasn't so obvious at the beginning, it was there that national regulators will have the ability to impose emergency measures. It wasn't so prominent, but the first 6 months of 2025, we really saw a lot of commotion. I mean, you saw Hungary coming out and just imposing their own regime out of a sudden. I mean, talking about Revolut, I mean, I remember I was on vacation, I was in a Greek island, and we had an emergency board meeting because, oh my God, are we, you know, I cannot visit Hungary because I'm going to be detained at the airport because I'm committing a criminal offense, because it was actually a criminal offense for any company to be transacting or to be offering crypto services unless they had what was called like a local national validator, which these are concepts that are not anywhere in MiCA. But you have national regulators that come out and they impose their own micro regimes, which kind of hinder the whole idea of passporting across the European Union. So this was one thing. The other thing was only 9 days ago, where you had the AMF, the Italian regulator, CONSOB, and you had the Austrian regulator coming out with a press release, a common press release, basically bashing MiCA. And this was unheard of, because effectively, the things that they were addressing on the press release were things that could have been discussed over the past 2-3 years through ESMA. But instead, you see them coming out, and I mean, reading through the lines, you can see that effectively they're talking about regulatory arbitrage, which, I mean, to be blunt, what it means is that, you know what, MiCA was implemented in the European Union. You have all of these big boys, you have Kraken, you have Coinbase, you have everyone that's someone in the game, and instead of going to the mainland, to the Central European regulators, where do they go? They go to the periphery. They go to Ireland, they go to Luxembourg, they go to Malta, they come to Cyprus, right? And I think this is not something that they expected. And it seems that ESMA needs to address these issues now. Like I said, this only came out 9 days ago. And it talks, I mean, in very strong language about regulatory arbitrage of some firms. It talks a lot about how do these players use offshore jurisdictions in their offering. And I think they're referring there to the concept of liquidity providers, to the concept of exchanges in offshore jurisdictions to facilitate trade in the European Union. Perhaps United States-based setups for crypto exchange or crypto trading facilities. So, and effectively, they indirectly threaten that they might be forced to impose the right of national emergency measures, right? So these are serious things.
Yeah.
And I think they all emanate from the fact that ESMA has a very democratic layout where each country has one vote. So the big countries don't have the strength in this forum to impose their views. So I think that they needed to come out so they can exert political pressure through the European Parliament in order to make some changes come through ESMA. But ESMA needs to address these things. So I see a lot of commotion.
Yeah.
Maybe it's not getting a lot of press. Maybe that's good. I don't know. But these are the things that kind of worry me. I mean, from the perspective of our European operations, both from Revolut and from my own personal practice. And then moving to the Middle East, and when I say Middle East, I'm focusing primarily in the GCC. So basically Kuwait, Saudi Arabia, Qatar, Bahrain, the UAE, and Oman. It seems that these are becoming the adults in the room, I mean, the crypto world. I mean, you're talking about regulators that are very, very serious. The UAE is definitely leading right now. It wasn't always like that. Bahrain was the first country that had a very, very solid regulatory framework for crypto exchanges through the central bank, through the Bahrain central bank. But the UAE caught up. The other countries in the region do not have a regulatory framework yet. I know that Qatar is really trying. Qatar is basically trying to emulate what the UAE is doing. So basically, they brought in a lot of Westerners in the regulatory organizations, in the regulatory structures, in order to help them to create a solid framework. And then you have the UAE. And talking about the UAE, it's very important to understand that when we talk about the UAE, we're not talking about one regulator, right? You have 7 effectively emirates, which they don't really emulate the European Union in the sense that these are country states, but basically they have a lot of autonomy. And out of the UAE, you have 2 main players that are calling the shots, right? You have the Abu Dhabi Emirate, and then you have Dubai. In relation to the crypto frameworks, you have the central bank of the UAE, which is responsible primarily for payments. You have the local regulator, again, at the federal level, which is called the SCA, the Securities Commodities Authority, that regulates financial services. And then you have the 2 main offshore jurisdictions in the Dubai and UAE respectively, called the DIFC, Dubai International Financial Center, and the ADGM, which is Abu Dhabi Global Markets. The Dubai International Financial Center has its own regulator, which is called the DFSA, Dubai Financial Services Authority. The Abu Dhabi Global Markets has the Financial Services Regulatory Authority. So these are regulators. And what's important is that they're both based on common law, right? The ADGM specifically, it's pretty much British law, okay? It's not even based. I mean, it is what it is. Even the judges are basically retired British judges that they take in the region. So basically, you have amazing clarity when it comes to what to expect. And the other very, very interesting thing about those jurisdictions is that the lawmakers are also Westerners. Again, we're dealing a lot with people that used to work for the FCA, for the Treasury Department. So you have a lot of Westerners that are basically responsible for these regulations. So you see things that are very, very relevant, but at the same time very practical and very doable and very easy to follow. It's very interesting to see. Now, in regards to the specific regulatory frameworks, you have a new regulatory authority that was created at the Dubai level, which is called VARA, which is the Virtual Asset Regulatory Authority. And what's really important about this is that this is a purely Dubai-based entity, but from my understanding, there is kind of an arrangement across the UAE that if a company gets a license from VARA, effectively they can offer the services throughout the UAE. It's not explicitly stated, but a lot of things there, you have to be on the ground to really get the nuances and understand exactly how they operate. At the same time, the DFSA has its own regulatory regime for crypto, which has not been very active because, remember, you have VARA also in Dubai, so they're effectively competing for this specific sector. And on the other hand, the ADGM also has a very, very specific framework for crypto-related companies. And just to show the interplay between all of the regulators, we have a very interesting project now for the issuance of a stable coin, a USD denominated stable coin. And the client had basically the authorization from the central bank of the UAE at the federal level. And then they are issuing their stable coin from the DGM, but the distribution will only be done from a VARA regulated company, right? So you have 3 regulators working as one, which, again, comparing to what's happening in Europe, where supposedly we have one regulatory regime and everyone should be working together, I mean, it just goes to show that things are very, very serious in the UAE, and people there really mean business, and they're willing to facilitate business.
So you've You've endorsed what I've heard anecdotally, that there are a lot of, particularly Bank of England, FCA regulators in the Emirates and Saudi, who are finding that they can, they've learned their trade here, but now they can do things faster, and perhaps, as you say, practical, but more innovatively as well.
Absolutely, and this was so refreshing to see, because basically you see regulation. I'm not exactly sure about the UK, but I guess in the UK it's probably similar. But in Europe, for example, you see that a regulation will go through a consultation. They will take years to be ratified and then implemented. And then you see things that are happening really, really fast in the UAE.
I think that the UK, as a sort of extra to yours, is we're kind of middle of the road. We've got a distinct lack of pace, and ambition isn't all there. It's not some of the ambition you've described or that we've heard about in the US. At the same time, it's certainly not hostile, but it's kind of, we're just sort of chugging along there at the moment, and we're trying to turbocharge it. I'm conscious, that's been like a fantastic tour, and I guess, between the emerging chaos in the EU, the complete volte-face in the US, almost the offshore jurisdictions actually having, kind of been quite early adopters and maintaining their presence. I guess it'd be really good just to sort of pulling that out, and you've touched on it in places, I think, where between wholesale and retail, and we talk about crypto assets, but we know that there's a huge number of different products and services, and between distribution and the infrastructure and issuance, etc. But if you take all of that, just looking into your markets, is there, if you're going to pick out kind of what's distinctive or where the sweet spot is for your markets, kind of, should we, just to tease that out? So we'll go back, we'll start with, again, kind of the US, where you're going to have more than one sweet spot in terms of what business strategy would kind of best fit for firms basing themselves in the US regime.
Again, just to sort of reiterate what I said earlier, despite all of the developments in the US, I don't see the big global digital assets companies changing their approach. There is so much to recommend a global strategy, placing the right product in the right place, looking to Singapore in particular. Hong Kong and Japan are also innovating, Middle East in particular, Qatar, UAE. There's just so much to kind of, I don't know of anyone in my space who isn't constantly looking globally. I think the US is the world's largest capital market by far and away. I think we will definitely see a desire to be able to access those markets, to be able to provide technology to those markets. I do see the fixed protocol, which is what the ATS, the alternative trading systems and main markets in the US, run on, eventually being replaced by blockchain along the lines of Singapore's global layer one. I certainly think from a state perspective, it's unlikely, I should have clarified, New York is still pretty hostile, and I think it will remain a difficult state jurisdiction. Wyoming is racing ahead and has been years ahead of many other states. Colorado, Texas, Arizona are all pretty innovative. So I think in the US, we will definitely see crypto exchanges exchange traded products that are investing in digital assets, and we will see tokenized securities increasingly. And that, I think you'll see that come in as a safety net under existing software, which is 30 to 50 years old and just creaking at the seams. And then we'll see it step up as the replacement. So definitely I see that activity, but in terms of the existing global strategies and jurisdictions that we look to for a range of things, and that's a question I think we haven't got to, but I don't see crypto forcing the world to become one big legal glob. Like that's crypto's not quite that important yet.
A really good point made about the tokenized, if you like, the plumbing, the infrastructure for all of financial markets. That's almost developing separately from, but interlinked with the individual products and services. Sarah, kind of, I guess, the USPs of some of the jurisdictions.
Yeah, so I think because Bermuda has had this very stable government policy objective to diversify the economy by having regulated digital asset business, the current regime is highly developed to allow startups, scale-ups, and then already fully, let's call them sophisticated players, people who have been operating elsewhere and want to operate from Bermuda. The regime in Bermuda has different classes of license with sort of light touch, not so light touch, and then sort of full-fat regulatory requirements. So if I have clients who are startups or scale-ups, they will love Bermuda. They love Bermuda because the regulator is very user-friendly. The fintech team will have phone calls directly with clients. Again, startup without too much budget can sort of cut its teeth in Bermuda and see what it's like to be regulated and continue to be regulated. For Cayman, again, I think that's an ideal jurisdiction for tokenized wholesale investment funds. There aren't eligible asset restrictions on what funds can invest in. So we see a lot of wholesale business as in the tokenized fund space continuing to favour Cayman. And then BVI, we actually at Walkers, we acted for BlackRock on their BIDL tokenized fund. That is proving quite popular as a jurisdiction for tokenized funds, which, historically the BVI has not been sort of front and centre of the funds industry. But again, the BVI, because it's not highly regulated and it's not a government policy objective to be highly regulated, a lot of clients who don't want to have a highly regulated business will look to the BVI to establish, say, a DeFi or prop trading business. And then Jersey, as I say, we're seeing huge demands from Europe, who will have, a Jersey token issuer as part of a broader strategy to sell a token into Europe via Liechtenstein or an EU provider. So I would say that that's a very well-trodden path and proving very popular.
Smashing. Yiannos, you've identified at least one market where you might get arrested for even stepping in, so to be avoided. But what are the standout jurisdictions for you?
Well, look, in the European Union, it's definitely going to be, the European Union, it's always going to be relevant because of, for the retail markets. But I don't think that any serious player is going to come to the European Union to try anything new, to be honest, right? The European Union, to be honest, they did publish the DLT pilot regime, which effectively talks about issuance of IPOs directly on the blockchain. Because now, again, I'm not a lawyer, but I see that many times you have these tokenizations that are effectively representations or mirroring of the value of another asset, right? It's not the asset directly being listed on the blockchain. So basically, the DLT pilot regime is basically trying to do that, but for financial instruments. But again, European Union, I think it's only about the retail at this moment in time. Some asset managers, but asset management of just crypto assets, nothing fancy, nothing too exotic. Whereas, again, in the UAE, forgive my infatuation with the UAE, but they're doing things the right way. Things are fast, things are happening. They mean business. You can tokenize assets directly. This is huge because basically you don't buy a building, then you go to the registrar's office and basically you claim it as yours, then you put it under a company, you fractionalize, or you issue 1 million shares, you fractionalize those shares, you put those on the blockchain. You don't need the wrappers. Believe it or not, in the UAE you can take the title deed and and digitalize it directly. So basically the token is direct representation of the ownership and the value of the asset. It's not based on a fractionalization done on a share of another company that was used as a wrapper for the asset, right? So there you have direct tokenization. And this is what makes it so important. And this is why I mentioned before that you have Western regulators. You have European, but it's primarily British, some American, a lot of Canadians and Australians. So you have people that are very practical, very pragmatic, but it seems that when they're freed up from the bureaucratic restraints, they can do miracles with the, with the regulation. And you have a regime that is really wants to project that they're a leader in this sector, and they're doing a lot of very, very interesting things there. So for anything new, anything exciting, I would definitely look at the UAE. And like I said, for Europe, I will be keeping the more traditional mainstream stuff.
And very, very quickly, looking ahead, we kind of picked out this question of do we expect to see? And when I talk to big financial institutions, particularly in the UK and maybe post-Brexit, they always long for harmonization and cross-border equivalence. And sometimes I find myself saying, well, those, you look at the president's address to the UN yesterday, that those days of international agreements are kind of over. They're done. They're not coming back for quite a while. But equally, it could happen by stealth. But I think I started this discussion thinking it sounds like actually the regimes may all start to slowly get to the same place. But as the more I've listened, the more I felt it really is a kind of vibrant patchwork of difference, and it's about firms, as you say, being mobile, shopping around, looking at how things are developing. But kind of in one or two words, well, how would you describe what you think the mix globally of kind of regulatory regimes might look like in, let's say, 5 or 10 years' time? Looks like Sarah, looks like you're ready to go.
I think there's one theme that we see running through sort of most jurisdictions' global compliance, which is the AML, the AML piece, which is businesses endeavouring to ensure that their business is not going to be exploited by financial criminals. So that we're seeing more and more. Even if there isn't a regulatory requirement, many of our clients who are not conducting regulated business will still want an AML policy, they'll want guidance on AML compliance, sanctions compliance. So that's part of my practice, is to work with, say, DeFi businesses and also unregulated business, as well as regulated business. What does good look like when you're looking at ensuring you understand the trends, you understand how the crypto business is vulnerable, can be vulnerable, and how do you, as much as possible, identify, prevent, and mitigate
So almost
risk.
a kind of global, maybe a global foundation level layer of AML. It's then what's built on top of that we see as different. Yiannos, and then I'll finish with AML. We'll go around kind of any other reflections on that, just kind of in a couple of words what you think the world will look like.
I don't see any kind of convergence. I mean, maybe just as Sara said, with the exception of the AML, because remember that you also have the CARF regime of the Organization of Economic Cooperation and Development, which is effectively about taxation. It's like the CRS, but for digital assets. Again, I don't know if the United States has ratified that. No, because the common reporting standard is not a US thing. So, but it can come pretty close, because you can have like 150, 180 countries ratifying. I mean, so some sort of AML convergence when it comes to the requirements. some sort of the travel rule, I mean, across countries, but I don't see anything else, to be honest. And to be frank, I think that even though a lot of innovation is going to be coming out of the UAE, for example, I think that there's going to be a lot of demand for offshore jurisdictions, and basically through the offshore jurisdictions to pass a lot of these innovations and make available a lot of these tokens through reverse solicitation, obviously, to the rest of the world. Oh, by the way, one of the other things that was mentioned by the 3 regulators that I mentioned before in the press release, again, was the ability of ESMA to protect Europeans from unscrupulous offshore setups. Well, they didn't say unscrupulous, but this is what they meant. But I think that at the end of the day, it's, buyer beware. I mean, we do have like a kind of convergence in the sense that all of the offshore regulators now have pretty solid requirements about who can come and set up shop and offer services. So I think that at the end of the day, we will have an unofficial convergence, but the only official one is going to be for AML and KYC purposes.
Emma, what's your worldview?
I am old enough that when I did my LLB, which was well over 20 years ago, you could still get a textbook on EU law. We didn't, it wasn't antitrust or external relations. It was, you could buy a textbook on EU law. You can currently, this is a symposium on blockchain and crypto, you can buy a crypto textbook. I'm a globally recognized blockchain lawyer. In 10 years' time, I will be back to doing just securities law for blockchain. At the moment, it's more important that I understand the technology and can apply a broad spread of law to it, because that's where we are at the moment. Because it's just so emerging, and that's the nature of it. But I see it changing the global geopolitics and the reasons why we have different jurisdictions applying different layers of law, civil law versus common law, and all of that history. No, I don't think crypto's that clever or is going to do that in 10 years.
That's a great layering of the technology with geopolitics and then the history of legal systems. So I'd love to, we could spend a whole another hour looking at those. Fantastic. Do we have time? Can I just check? Do we have time for questions? We've run out of time. I do apologize. But you can kind of grab us. I think it's the coffee break next. So grab people if you have got questions. Huge thanks to the panel. That was fantastic. I guess what it does show is there's definitely plenty of work for lawyers and advisors around the world for all of you to pick through all of these issues and opportunities in finding the right markets. But thank you very much.
Thank you.
Thank you.